So let's talk about CPS. CPS, or in Texas, it's the Department of Family Protective Services. We call it CPS because that's just kind of the general thing. Everyone knows what that is. CPS gets involved in family law cases in a few different ways. Here's how it typically works. Someone will call in a complaint saying that the children are in some kind of danger with one or both of the parents. And CPS will launch an investigation if it rises to a level they think is worthy. In a very worst case scenario, the department has attorneys on staff that will file a case to remove those children from the home like right away. And the first time you know any of this is going on is when a CPS person and a deputy or some law enforcement show up from your house to take possession of the children. That may very well be the very first time you find out that CPS is involved in your case. Below that is where they will do an investigation. CPS will do an investigation, and if the parents cooperate with the investigation and the department doesn't think the children are in immediate danger that require removal, they will take some other actions to protect the kid. It could be what they call a safety plan, which is a plan that restricts some behavior of one or both parents and helps protect the children in a way that doesn't require the children to be removed by court order. And then the third way that CPS can get involved in a case is they do what is called an alternative response. An alternative response is some kind of threat to the children that the department doesn't feel like is really terrible, and they could probably fix this problem with just helping the parents with some classes and some other resources to help the parents in their parenting relationship with the child. Here at my firm, we help parents when CPS is involved in their case. If the department has filed a removal, then we are happy to help represent one or both of the parents in that litigation to try to get the children back and do what we can do to get the children back in the household and get the department out of our life. What we see most around here is when the department is filing an investigation, someone has called in a complaint, someone has called in a call that one of the children, one or more of the children are in some kind of danger, and the department calls you up and says, "Hey, this is so-and-so, I'm from Department of Family Protective Services, and I would like to meet with you about an issue that's been raised with your child." And then they want to come to your house and do an interview. We prefer to host those interviews, or at the very least for us to go to your home to help supervise that interview, if you will. So even though a legal case has not yet been filed, you are still, as a parent, interacting with the department, and we can represent you in that interaction. We can be there to support and guide and counsel you through that interaction with the department so that we keep the department reined in and keep things focused and help get you back on track with your kid and get the department out of your life as fast as we can. And we do that same thing on the alternative response program, although it's just a lower level, it's a lower intensity. If you find out the department is involved in your life, CPS person shows up at your door, CPS person calls you on the phone and says, "I need to have a meeting with you about these allegations," don't talk to them. Tell them, "I'm happy to talk to you as soon as I get my lawyer," and then give us a call. Happy to have that talk with you, guide you through that whole process, and then meet with the department, meet with them, and help supervise that investigation and help guide you through that process, even if it never goes to court, which is the dream. The dream is to get you through the process, satisfy the department so they can go ahead and all the way off and get out of your life. I know that those workers down at CPS, I know they have a good heart. They mean to do good work, but they will ruin your life. I don't care how friendly they sound. I don't care what they promise you. They are building a case. and they will build a case, and they will be in your life, and they're threatening to take your kids away. They're threatening to go to court and get the court to order the kids be taken from you if you don't cooperate. And then when you hire a lawyer, they say, well, everything's voluntary. Everything's voluntary. They will lie and lie and lie and keep lying until they get what they want. And they want to be involved in your life. And the more nervous and scared you are, the more they want to be involved in your life because they love that. Sorry, I know that's going to make some people mad, but it is what it is. Okay, that's my experience in doing this with dozens of cases, with dozens of people, and dozens of different CPS workers from all over this area. If they call you up and say, hey, I've got a complaint and want to talk to you, you for sure need to give us a call, and let's schedule a time where we can all meet, and then we can keep this investigation narrow and focused and hopefully get them out of your life as fast as we can. So legally, anytime you're interacting with department, with CPS, it's all voluntary. They don't make it sound voluntary. They make it sound like if you don't do it, they're going to go down and file a case, and then the lawyers are going to get involved, and the court's going to order the children to be removed. And they'll do it. They will do that. Sometimes they actually go and they get the lawyers to file a case and get the court to order the children be removed from you. And that's the first time you ever find out about the case at all. You don't even know CPS is in your life until they show up to take your kids from you with a court order. So what are your legal rights? Well, obviously you have a right not to incriminate yourself, right? You've got Fifth Amendment, so you don't have to testify about things that could get you in a criminal court. You also have the right to have an attorney represent you in all their proceedings, whether it's just an investigation, whether it's an interview, or whether it's a court proceeding. And so you've got the Constitution on your side. The rights of a parent are constitutionally guaranteed. The court has to feel like it's in the child's best interest to remove you, and certainly to remove you in the long term or terminate you as a parent. There's a high burden for that. So you've got a lot of rights, and I'll just tell you that CPS worker is not going to tell you those rights. They share, they disclose all those things, but you can't necessarily trust what they say. So be really, really careful. I definitely recommend having a lawyer with you anytime you interact with CPS. I think the vast majority of cases that CPS are working with will get resolved over time through a safety plan and through family-based safety services. And so it's kind of a different department from the investigative side, but most CPS cases are going to get resolved through a safety plan that results in family-based services, and eventually the department closing the case. As far as the legal side, once it gets into court, if your case escalates up to, you're actually going to child protective court where there's judges and there's lawyers and there's CASA workers and all these other people, you damn sure need a lawyer on your side for that. Just so you know, if the court is considering terminating you as a parent, you can have a lawyer appointed. So I just want to be transparent about that. You don't necessarily have to pay for a lawyer like us to do that work. If the judge is considering terminating you, they'll appoint a lawyer for you. If the judge is not considering terminating you, they will not appoint a lawyer. That's for sure when you need to hire one, because they can still wreck your life for the foreseeable future if you don't have a lawyer there to represent you in court. Most cases are resolved at the investigation level, and that's where you get that sheet in the mail that says they found a reason to believe that the allegations were true, that you somehow abused or neglected your child. Or they might have they ruled out the allegations. They might have an unable to determine. So they looked into the facts and they couldn't figure out if the allegations were true or not. And then, of course, they can have no reason to believe. So they don't believe that anything happened. They believe that the allegations were false. Most CPS investigations are going to end in one of those dispositions. Reason to believe, ruled out, unable to determine, or there's no reason to believe. So once you get that, those results, if they're negative, can be appealed also at the administrative level. Those could be appealed. Here's a pro tip. A negative finding on a CPS investigation can turn into career-ending problems for you. For example, if you're a teacher or you have a security clearance with the military or something like that, or you have worked for the feds, you have security clearance. If you work in a nursing home, if you get a reason to believe or even an unable to determine, you could lose your security clearance. You could get fired from your job because no job wants the liability of having an abuser working with children or working with elderly or something like that. So a CPS ruling, even though it doesn't affect your life on any given day, even if it's negative, can ruin your career. So you have to take them really seriously beyond just trying to protect your family unit. One other aspect of a CPS case is they often happen concurrently in a family law matter. Here's a couple of situations that occur. So imagine someone calls in a CPS report against you. They call in allegations of abuse or neglect in some way. As soon as your co-parent discovers that you have an active CPS case, they will often file to modify the possession schedule. A CPS case can be the starting point for additional family law litigation. So, for example, if you and your new significant other get in a fight and your neighbor calls the cops and the cops show up and they think something's going on, they think some family violence has happened, and the children are present in the home, the police will call CPS. If you take your child down to Cook's and the child has some kind of injury, if they think there could be abuse, they will call CPS on you. Cook's is like the worst, just so you know. But they will for sure call CPS if they think there's any possibility that this child's injuries occurred because of abuse. Once CPS is in your case, the other parent finds out that you have an active CPS case, they're going to file a mod. If you're fighting with your new significant other, that's a material and substantial change. So now you got CPS on one hand and you got the other parent coming in on the other. So that is a huge risk of CPS cases. And once your case gets to court, then one of the big questions is how does the judge interpret your CPS investigation? CPS workers are often called to testify. If we file a case because the other parent has an open CPS case, we're going to call that CPS worker as a witness to tell us what that CPS worker knows. So the CPS person can be involved in your litigation as well. And then, of course, if there is a reason to believe that abuse has happened, the court very likely is going to make a finding that family violence has occurred, and now that affects your rights in conservatorship ruling at the end of the case, right? You can't be a managing conservator if there's a finding of family violence. A CPS finding that the allegations were true, that you abused the child, could land you a family violence finding by the court. Even if CPS doesn't take you to court, you could very well land in family court because of a CPS case. So if CPS gives you a call and they want to talk to you, for sure, give us a call. We'll be happy to help.